Hello, and welcome to the latest Insights Live, Building Your Estate Plan, the first of our three-part series this month on estate planning. I'm David Peterson, head of Advanced Wealth Solutions here at Fidelity. Thank you for joining us and for submitting questions to help form our discussion. I'm joined today by Pamela Perrone Benson, an advanced planner based in New Jersey, and Jacqueline Calandriello, a wealth planner based in New York City. Before we get going, I do need to let you know that Fidelity does not give tax or legal advice, and nothing we discuss today should be interpreted as tax or legal advice. The information we're providing is going to be general in nature, and it may not apply to your own situation. If you have tax or legal questions about your specific situation, we encourage you to talk to your attorney or tax professional. So let's go ahead and get started. In my role, I talk about estate planning a lot and to people in a variety of circumstances. One thing I've come to realize is that this phrase means different things to different people. Some think it's only for people who make a lot of money or who have a lot of money, while some think it's only about estate taxes. And sometimes when we talk about estate planning, we get a statement like, this has been great, but when do we get to the estate planning? So I want to start with a definition. Pamela, when we at Fidelity talk about estate planning, what does that mean?
It's great to be here, David. It means more than just a beneficiary. A lot of times I get, oh, well, I have a beneficiary on documents, but it's more than on accounts. It's more than just a beneficiary or a single document. It means having a discussion, right? We're going to talk about that, putting a series of key elements in place that are designed to work together. It's about making sure your family's protected and your wishes are carried out. It's really about creating your legacy and trying to make things easier for not only yourself, but for your family, your loved ones, and those who might be a part of your estate plan.
Great. We also hear that many people are reluctant to start the process of estate planning. It's an emotional topic that unavoidably addresses topics that are really hard to face, like incapacity and death. Pamela, in your role as an advanced planner, you work with clients every day. How should someone start this process?
Well, it's true. Who wants to sit around thinking about death and taxes? But when thinking about estate planning, keep in mind that if you don't make decisions for yourself and put things in writing, the state may decide them for you. So while estate planning may seem like a daunting task, I always say, take it small, start small, take it in phases, right? First step, think about what your legacy is going to look like and who do you want to leave your assets to? And then the attorney can help you with how you're going to leave those assets. And there's no one way to do things, right? That's sometimes what's frustrating. Attorneys can help guide you in those different options. Estate planning is also definitely, as you said, David, going to bring to the surface some emotions, right? And that's okay, but you just have to try to keep focus on getting something in place. Before seeing an attorney, in addition to understanding who, you want to understand also what you have, and your financial professional can certainly help you with that.
Okay, so we're going to get into much of this in depth during our time today. But first, Jackie, you're a wealth planner who helps clients create long-term financial plans. How do you help with estate planning?
So, David, I believe that an effective estate plan will begin with having a sound financial plan. And that's when I'm going to work with my clients, and together we're going to co-create a financial plan that will really be based on what their unique goals and objectives are. And not only for themselves, but also for their loved ones, as well as the causes that they might care about. And when we're thinking about this financial plan, we want to have a holistic picture, including their assets, their liabilities, income, expenses, if there's any insurance in place, as well as how are the accounts owned and what are the beneficiary designations that they have in place. Then we want to evaluate how their estate is projected to grow and assess if there's any potential estate tax issues, as well as how much they can allocate towards their goals if there are goals for gifting or for charities. And I also think it's important to really understand what would be the impact of an unexpected health event, and how do we address that? Should we be looking at self-insurance or potentially looking to actually transfer risk and obtain insurance? And we also want to evaluate, do they have the correct documents in place to meet their estate planning wishes? And that's when we'll often work with Fidelity's advanced planning team, including Pamela, who I partner with often, to review the estate planning objectives and educate our clients on what they should consider putting in place to meet their wishes under not only the current estate tax laws, but also the state in which they live.
Yes, and we frequently say everyone has an estate plan. Pamela, you touched on this earlier, meaning the state has a protocol for how assets get distributed at death, unless you specifically tell them what you want. So not creating a formal plan means that the state will make decisions for you. And there's a good chance those allocations won't be the same as what you might decide for yourself. So Jackie, can you give us the rundown of the critical documents that everyone needs to help alleviate this?
Yes, of course. So the 4 core documents will be your will, power of attorney, healthcare proxy, and living will. And when we think about the will, this is a document that's going to outline who's going to receive your assets after death. And that's going to be for anything that's not passing by way of a contract like a beneficiary designation, or by law such as joint ownership, or by terms of a trust. And a key point to keep in mind that's often overlooked is that your beneficiary designations will override what is stated in your will. So if your will states that everything is going to go to your spouse upon passing, but you named your child as beneficiary on the actual account, the account will go to your child and not your spouse. And that's where it's incredibly important to ensure that you're coordinating your finances and your estate planning wishes. And then if we think about the will, it's also going to designate an executor. And that's the person or institution that will oversee the settlement of the estate and carry out the instructions in your will. And then for those of you with minor children, it will also designate the guardian. And then we have the power of attorney. And that's a document where you're going to grant another person the ability to make financial decisions on your behalf. And that could include things like how to invest your assets, take distributions, paying bills. So think of this really as the person you trust to handle your financial affairs if you become incapacitated. And then we also have a healthcare proxy. And in some states, it'll be referred to as a medical power of attorney. And that's a document where you're going to authorize someone to make medical decisions on your behalf if you're no longer able to do so for yourself. And then the 4th document is the living will. And that's going to guide your healthcare proxy on your preferred end-of-life decisions, as well as medical interventions. So you could think of things like, do I want life-prolonging treatments, artificial life support, the use of feeding tubes, do not resuscitate orders. I know that Pamela and I have worked with clients where they've also included preferences on receiving home care or facility care. Do they want to be buried or cremated? And sometimes even include religious preferences. And this document is so incredibly important because it will not only assist your healthcare proxy, but also your loved ones and ensure that they're aligned to make sure that you're receiving the best care in the manner that you intended.
Jackie, I'm so glad that you brought up the living will. I think a lot of times clients will say to us, oh, my family or my friends really know what I want. But putting it down in writing can be so important. I remember being together with a family end of life where the person was passing away and there happened to be multiple children in that case, and they just didn't see eye to eye. And we were able to dig out the living will. The parent put it in writing, and that really helped bring them together and execute their wishes. So I love the idea of sharing the wishes with the family, but getting them down in writing as well.
Thanks, Pamela. That's a really great example. So, okay, so those are the basics: a will, a power of attorney, a healthcare power of attorney or proxy, and a living will. We'll get into trusts much more deeply next week. But Pamela, if someone has a will, would they also need a trust?
If only I had $1 for every time I got that question. So during my career, probably the number one question I've been asked. And unfortunately, there's just no one size fits all answer. There's no book you could read. There's nothing that's going to tell you whether or not you need a trust. It really depends on a number of factors. And there's so many reasons, as you mentioned, we'll talk about them next week. But keep in mind, trusts are not just for the wealthy. It's not just about saving on estate taxes. If you add a trust to your estate plan, it gives you the opportunity to specify how assets might be administered during your life or after you pass. A trust can have a lot of other benefits, right? I call it the in-law or outlaw trust sometimes, right? The in-laws that become outlaws, divorce, giving you greater control over distributions. Maybe there's creditor issues. Maybe we have to avoid estate taxes. Maybe there's a special needs issue. Maybe there's some type of tax efficient investment strategy, right? A lot of different reasons. Maybe you have charitable intentions and there's a reason to use a trust there. So again, as I've illustrated, a lot of different reasons to use a trust. You definitely want to talk to an attorney to really determine what type of trust and if a trust is even right for your situation to begin with.
Awesome. So let's just say, I've worked with an attorney to have all these documents drafted and executed. Where should I store them to keep them safe and useful?
Yeah, well, as we see sometimes in the news too, and with celebrities, your estate plan's only as good to the extent that somebody actually knows where to find it, right? We don't want to kind of hide it and you can't find it. I think you're going to decide on a combination of both, right? Electronic and physically. Namely, because in some states, you still have to have your original will be admitted to court. So you can't entirely go paperless. You want to have a fireproof safe vault. That's what I have in my home with important documents, your estate planning documents, maybe the deed to any real estate properties. That letter you want to write, right? Outlining kind of where you want assets to go. We're going to talk about tangibles, where you want something to the bracelet or the ring to go to that specific person. And of course, then you want to make sure somebody knows where to find it and how to access it as well. It's also beneficial to have your documents stored electronically, right? That's an easy way to share it with your executor or your power of attorney. They have them electronically. They don't want to keep paper. Also, think about if you're traveling, right? If you're traveling and you get sick, if you have multiple homes in multiple states, if you have them electronically, it'd be easy to access your healthcare proxy, for example, in that case. And preserving your original documents is definitely important. And we talked about the will. Jackie, I could think of a situation where a client came in and their will was completely unstapled, right? So if you have your will out there, don't unstaple your will. It could potentially cause an issue. So keep those original documents intact and tell somebody where to find them.
Yeah, that's a great point about unstapling the will, because the first thing the court's going to look at when they go to probate the estate is look to see if the will has been tampered with. And unstapling it could be an indication that it's been tampered with. So important point to remember. All right, let's guide our audience through the wealth transfer process and why these documents are important. How do assets pass to heirs, Pamela?
Yeah, and that's really important, right? So you have to think about there's 4 ways: beneficiary, by law, by trust, and by probate. So by beneficiary, most frequently applies to think retirement accounts, 401ks, life insurance, annuity contracts, right? Roth IRAs, maybe some saving and investment accounts. Beneficiary, Jackie, you said this earlier, beneficiary controls the distribution of where your assets are going to go. There's some consideration as to whether or not you use a beneficiary and who that beneficiary is. You have to keep in mind with coordinating that with your last will and testament. When naming individual beneficiaries, right, that's something to consider. If you name individuals, you may lose protection of passing those assets in a trust for a beneficiary. So again, beneficiary overrides. For accounts that increase and decrease in value, you want to think about using a beneficiary or not, because you can't easily assess how much going to be left there when you pass away. And also when using a beneficiary designation, be mindful that it must be updated each time a new account is open, right? You have to add it to that new account. You also need to think about updating it because people pass away, people get sick, different things could happen. Second is by law. So these are typically assets that pass joint with rights of survivorship. You own something joint with rights of survivorship, tenant's entirety, one person dies, it passes to the other. We often see that in the cases of real estate, maybe joint bank accounts. So that's keeping that in mind. Keep in mind in states with community property laws, spouses are usually co-owners of any assets acquired after the formation of marriage. So that's a consideration when you're thinking about passing by law. Community property may be transferred automatically, provided that the asset is properly titled, or maybe there's some kind of community property agreement. But in the end, right, you really need to think about how it's titled. Is it joint with rights of survivorship? You could also, in some institutions, put payable on death or transfer on death on different accounts to serve as a beneficiary in that case. Then we have by trust. Right? A trust is an arrangement. The trustees of the trust hold the trust assets on behalf of the beneficiaries, and they're passed based on what the trust agreement says. So if an asset's in a trust, the trust agreement dictates where the assets go. If you're using a trust, you have to consider that the trust governs those assets owned by the trust. I know we're going to talk a lot about that next week, but trust assets include only those assets that are titled in the name of the trust. And then, hey, the last way, right, where we always hear and see articles written about by probate. So generally speaking, if an asset doesn't pass by law, doesn't have a contract, or it's not in a trust, that's the asset that's usually going to pass through heirs, through probate via a will, through a legal process known as probate. So depending on the value of the estate and which state the deceased resides in, probate could take as long as several years and the fees could be significant. So that's really important. You want to think about bringing an attorney in, talking to them and understanding what the probate in your state looks like. You also want to consider that probate's a public record. I once met a neighbor who used to go to court and read people's wills. I'm not sure why, but it's public. So it decreases the level of privacy for your family. If you own real estate in more than one state, there will be multiple probates and ancillary probate. So a couple of things to keep in mind, because that could further complicate the settlement of your estate.
And Pamela, you mentioned about how important it is to coordinate your estate plan with your financial plan. And I was just thinking about how we worked with so many clients where they did a really great job thinking through who they wanted to receive their assets, whether it's individuals, family, friend, charities, and they've entered all these bequests within their will. But then they've gone and they've added beneficiaries to all of their assets. And there was nothing actually left that was going to flow through the will to actually make these bequests. So that's where it's really, really important to just make sure that you're working with your financial professional as well as your estate attorney to coordinate your estate plan with the financial plan.
Great point. There is an order to these things. And I also like the point, Pamela, that you were making about a trust to do anything. It has to actually have assets in it. Otherwise, it's not going to do anything. So again, we'll talk about that more next week for sure. But one question that often comes up is about spouses. So often we hear that someone thinks they don't have to do any of this planning because their spouse can just step in and handle everything. At the risk of leading the witness, Pamela, does anything happen automatically? What rights does a spouse have?
We're in criminal court leading the witness. So. The misconception is that a spouse automatically inherits everything, and that because you're married, your spouse has automatic rights on your behalf. It's absolutely not true, right? If you pass away without a will, a lot of states have rules that say assets don't automatically all go to the spouse. Marriage does not automate things, right? Even spouses should have documents to make sure that who and what you want to control things in writing. You don't want there to be any lack of clarity, right? We think about blended families as well. For example, if you have an IRA and that asset is in your own name, right? Think about estate planning if you're sick versus if you die. Jackie talked about that power of attorney. If you have an IRA in your own name and you're incapacitated, your spouse does not have automatic rights to call, up and ask questions and understand what's going on with that account because it's in your own name. And a lot of times, David, clients will say to me, well, there's a beneficiary. Well, that's great if you died, but it's not helpful if you're incapacitated. So not automatic rights for spouse.
Great point. So it sounds like, good asset titling and beneficiary designations might indicate that you don't have to do anything further. But Jackie, if someone has done a good job with their assets in terms of beneficiaries and titles, do they still need to do formal wealth transfer planning?
David, absolutely. So I think, like you said, proper titling of assets, naming beneficiaries, that's a great start. But it could leave you with some potential gaps or unintended consequences. And if you think about naming beneficiaries or potentially multiple, then as Pamela mentioned before, you're leaving those assets outright and directly to those heirs. And that might be the intent, but I've seen many cases where maybe there's a minor child or somebody who's not financially able to manage the assets. And that's where they can be mismanaged and wasted. So when I think about the wealth transfer, you also want to think about your heirs, as their needs may be different or their tax situation may be different. I'm working with a client currently, and there is a sizable pre-tax retirement account. And under the current laws, their two children will have to fully distribute the value of that IRA upon passing within 10 years. So the daughter right now is in the highest tax bracket, but their son is in a fairly low tax bracket. And as we talk through the family needs, they decided to leave a larger percentage of the pre-tax assets to their son than their daughter, and then they looked to equalize the remaining estate. And this is working perfectly for them, but I think it's also important to remember that there is no requirement to leave assets equally, as I've certainly worked with clients where they decided to distribute assets in different percentages based on need or sometimes even preference. I think other considerations will be, well, what if you only name one beneficiary and that beneficiary predeceases you? Well, then that asset will pass in accordance with your will. And then what if you have a beneficiary who might have special needs and is receiving governmental assistance? If you leave assets outright to that beneficiary, you can disqualify them from their governmental benefits.
Great. I love your example about really the integration of estate planning with the types of assets that you're leaving, with the income tax and estate tax implications for not only you, but also the people that you're leaving the assets to. I think those are super important considerations. So far we've been talking about how assets pass at the end of life. What documents you need to ensure the efficient transfer of them? The clients often ask about estate taxes. Pamela, what do they need to know about that?
Well, they need to know you pay income tax your whole life and then you pass away. There's a price to die. We call it the estate tax. The lifetime gift and estate exemption is the amount that each individual can gift to or leave to their heirs before triggering an estate or gift tax. So between spouses, there's something called an unlimited marital deduction, right? Keep in mind that the lifetime gift and estate exemption is different from your annual exclusion, which we're going to talk about. And the government puts a limit on that lifetime exemption or lifetime limit. And now in 2026, it's $15 million per person. And that amount generally rises each year based on inflation. Of course, the law could change and that number could change as well. Now, if you are married here, spouses may be able to combine their federal gift and estate tax exclusion, allowing them to transfer $30 million free from federal transfer estate taxes. If the first spouse dies and doesn't use up their exclusion amount, meaning, right, the first spouse passes away and they haven't given away any of their $15 million, the surviving spouse can elect to use what's left. We often refer that as portability. I call it combinability, right? Take each of your $15 million if you're married and combine it. Just a couple of things, David, to keep in mind with portability, though. If you have the unfortunate loss of your spouse, it's not automatic. A spouse needs to elect that option on the deceased spouse's estate tax return. So definitely want to see your lawyer and your accountant, keep them in the loop in that instance.
Great pointer. So you have this lifetime exemption and then you have the annual exclusion. How do these things work together?
Sure. So there's the lifetime exclusion. There's also these annual exclusion on individual gifts. What your annual exclusion is, it doesn't affect your lifetime exemption. So, kind of think about them separately. In 2026, an individual can gift up to $19,000 a year to another individual without incurring any kind of liability. That's your annual exclusion. There's no limit on the number of individuals that can be made. So couples, so think multiple people, $19,000 to those multiple people. And think about if you're married again, you can double that amount and elect to split gifts. So for instance, if two spouses with two children, they can give $38,000 in annual individual gifts for a total of $76,000. That doesn't create any kind of taxable gift. It doesn't use any portion of that $15 or $30 million. Again, different. And you could do both too, right? We're going to talk about this next week. There's annual gifts as well as making a larger gift above the $19,000, right? That's where then you start to use your $15 million exclusion. You definitely want to speak to your accountant and your attorney to make sure that they're on board and to make sure they're filing a gift tax return if you go above that $19,000.
Great. So obviously, again, we've been focused on assets passing at end of life. But one important thing that people may not talk about enough is the fact that not all wealth transfer has to take place after death.
That's true.
Jackie, how can someone decide how much to gift now?
David, I think that's a great question and something that my clients and I often look at together. So, as I mentioned earlier, when I'm working with my clients, we're really focused on co creating a holistic plan focused on their goals and objectives. And I will run what's called a Monte Carlo simulation. And that's essentially a tool where I'm going to stress test their plan in various market conditions to assess whether they're on track to sustain their lifestyle and needs and meet their goals. And if they're on track and their plan is strong, we will then evaluate their spending capabilities annually. So think of that as the amount that they can spend each year of their life while giving themselves a high probability of never outliving their assets. Now, when we have an idea of that spending capability, that could be on personal expenses, it could be on gifting to family or friends, or charities, of course. And with charities, there's a potential tax savings as well. And then when I think about those larger gifts that Pamela was just mentioning, many of my clients look to make these larger gifts, especially if they're trying to help support their children's or grandchildren's education. Sometimes it's helping with the down payment or purchase of a home. And that's where I'll build a scenario to try to incorporate that larger gift and assess the impact on the plan and the overall probability of success in meeting their own needs and objectives. And I think that's truly key because when you're thinking about those annual gifts or larger gifts, you really want to understand the trade-offs. And I'm working with a client currently, and these clients helped their daughter several years ago with the down payment for a real estate purchase. And they indicated they intend to do the same for their son. It's been several years since they originally helped their daughter. And their son feels the gift should be higher to account for the impact of inflation. And he also wants to try to get these funds in a lump sum rather than over a few years. So we took a step back and we wanted to assess what would be the impact to the parents. And what we found was that there was more stress with that lump sum gift versus spreading it out over 3 years. And when we're working with the family and discussing the impact, as well as the effect on the withdrawal strategies for the parents and their tax bracket based on the need to actually draw down from their pre-tax retirement assets to fund this gift, they agreed to structure the payments over a few years. And the son agreed as well because he didn't want his own desires to negatively impact his parents' financial stability. And then when you're thinking about structuring these gifts over time, it's actually allowing them to preserve a larger amount of that lifetime exemption that Pamela just mentioned. So that's something as well as we also want to think about what the current income tax and estate tax laws are, including that annual gifting limit and the lifetime exemption.
I love that example about how you brought the whole family together to have a conversation about the topic that sort of satisfied all of their needs. I think that's a really good practice. You also mentioned charity. So obviously, in addition to providing for heirs, many clients are also interested in philanthropy. So how might your estate plan help you meet your charitable goals?
Yeah, absolutely. I have a lot of clients where they want to leave assets to not only individuals, whether it's family and friends, but charities. And with the philanthropic aspirations, we want to evaluate the overall estate planning objectives. And is there a certain dollar amount or percentage that they want to leave to the charities versus to individuals? Because when we think about asset types, the tax treatment will vary when being inherited. So philanthropic planning can be incorporated as a broader, more tax-aware strategy. And the approach is intended to thoughtfully consider potential implications for the heirs, charitable beneficiaries, and tax obligations. Now, when we actually think about the mechanisms to complete this charitable giving, there's quite a few different avenues. So one is you can name a charity directly as a beneficiary on an account. You can list a bequest in your will to designate a specific dollar amount to the charity. There's also charitable trusts that can be established where you can actually have a split interest where it's providing income while also supporting charities. And then a strategy that I and many of my clients use, there's something called DAFs or donor advised funds. These are charitable accounts that allow donors to make a tax-deductible contribution of various assets. So it could be things like cash, stocks, bonds, even private business interests. And you can fund this during your life as well as through your estate plan. And as part of your estate plan, you can also fund these accounts with pre-tax retirement assets. And when you think about the donor advised fund, it also allows you to have many legacy options. So you can choose to leave the assets to one or more charities. You can also name a loved one who can take over the fund when you pass, and it'll allow them to make their own charitable recommendations. And then there's also endowed deaths or donor advised funds. And these are funds that allow you to establish long-term support through annual distributions to charities. So the clients can establish recurring grant recommendations for certain charities rather than leaving those assets as a lump sum. And that allows the gift to actually potentially continue into perpetuity. And when you think about the organizations who's receiving this support, it can also provide them with more stability and predictability in knowing that they're getting a certain amount each year.
Yeah, I'm glad you mentioned the DAF. I use that as well, and I like it because of the flexibility that it provides, which you outlined there. Pamela, let's bring you back into the conversation. Besides where your assets will go, a key part of the process is selecting the people who will help you carry out your wishes. So can you talk about the different roles to consider in your plan?
Absolutely. And I think a lot of times the who, David, is what holds up people. And, if you're thinking or you're struggling with who that is, you want to talk to somebody, right? There's a lot of different options for the who. But you got to think about, again, if you're sick versus if you pass away, you're going to need an agent under the power of attorney to make financial decisions, a healthcare proxy person for your medical decisions. You're going to need an executor under your will. If you do a trust, you're going to need a trustee, somebody that's going to be available to operate the trust. If you have minor children as well, you're also going to need a guardian, a person that's going to step in and be the parent if you're gone.
Right. So let's save the trustee role for next week when we talk about trust. But today, let's dig deeper into these other roles. So how do you help clients decide who should be their power of attorney or their healthcare proxy?
Yeah, so being a power of attorney or healthcare proxy is a job, right? Nobody wants it, but I always say somebody has to do it. And you definitely want to decide who's going to do it than the state you live in deciding or somebody becoming guardian for you. But there's a lot of things to consider, right? When choosing a fiduciary, you want to think about how old are they, right? If you're naming them as a trustee for a child or a younger niece or nephew and they're 5, 6 years old and they're your age, or maybe you've named your parents, you have to think about, are they really going to be around age-wise to be able to make those decisions? You have to think about where they live, right? That's important. Their responsibility factor. Can they be objective, right? Make the best decision based on what you have in front of them. Is their experience, right? If you're going to turn over a couple $1 million to them, are they comfortable managing those assets and understanding that? What's their skill set, right? Maybe they're more artistic and less financial and they don't handle their own finances. Something to consider. Jackie, we talked about the family conversation a little bit, right? Family, fairness, financial, family dynamics. Are they willing to do this? I think the best thing you can do is have a conversation with those people. I remember a client talking to me about that. Every year she had family lived all over the place, and every year everybody came together at Thanksgiving. And she would bring up death and taxes at Thanksgiving. And one time, and I was thinking, I'd rather be eating turkey. But anyway, she went ahead and she said, so-and-so, I've named you as my healthcare proxy. And that person responded and said, bad decision. I'll leave you on machines forever. I'm never going to take you off. So, just understanding what they really feel about making these decisions and letting them know is definitely a smart one. Another one, we talked about family dynamics. A lot of times clients will knee-jerk reaction and say to me, oh, I'm going to name the kids get along great, and I'm going to name them on each other's trusts. And I'm thinking, well, if you want them to continue to get together, get along great, maybe you don't want to put them in charge of each other's finances. So I think, David, the point here is don't just kind of make a knee-jerk reaction, right? Definitely think about who you're naming and take some consideration there.
Yeah, and in your example, those clients should be complimented for even having the conversation, because as we know, a lot of people don't. And when they have those conversations, then they find better answers and solutions to what they're trying to solve for.
Absolutely.
Another critical role is the executor of a will. Jackie, what are some of the considerations for selecting an executor?
Yeah, so I think it's important to first think through what the role of the executor is and the responsibilities. So, your executor is going to be that fiduciary that's going to handle the distribution of the decedent's estate pursuant to the will and will see that settlement through to completion. So, if you think about those tasks, that's filing court papers, it's paying taxes, it's fulfilling financial obligations of the estate. And it's ensuring that the assets are being distributed in accordance with the estate plan. So if you think about those many responsibilities, you want to think about choosing someone who you feel is trustworthy and responsible, as Pamela said, someone who's willing to take on the responsibilities of being the executor. Also, age is a consideration. If you're thinking about the age of the executor relative to your own, and potentially they're not going into that role for several years or even decades, then would they be capable of fulfilling these duties or even willing to do so? And then you also want to think about naming an alternate. So if your executor was unable or unwilling to serve, you have a backup who can serve in that capacity.
Great. Now, you started to touch on this, but after all these plans are in place, Pamela, maybe you can take us through how the process of estate settlement works.
Sure. Yeah. We talked about kind of having the conversation, but also making sure you stay organized. So keep in mind there's a difference between probating an estate and administering an estate. And I think they're often confused. If you have assets in several different places, the process is going to take longer, right? You're going to have to complete different paperwork at different places. That doesn't mean that the court is taking longer. It means that your legwork is taking longer going to these different places. Just make a checklist for yourself, right? Stay organized, have a list of all your assets. Maybe you want to understand in advance what each institution you work with might need. For example, you might need a death certificate, letters from the courts. You may need to notify parties. Some places may require notary signatures, some may not. Keep in mind, you're going to need to open up an estate account, right? And if you open an estate, you're also going to have to close the estate. So, you get the point here. It's a job, right? Administering the estate. And in the end, having an estate plan in place is definitely going to help your beneficiaries gain access to assets faster, right? That's the point. It's going to take even longer settling an estate without documents. So without an estate plan, your beneficiaries could wait while the assets sit in probate for a much longer time. Fidelity, we want you to think about that probate process. You could be liable for an average of maybe $38,000 in attorney and accountant fees. That could be based on an estate value between $1 million to $5 million. So it could get expensive. I think about clients I met recently, a younger person who lost both of her parents. And she said she's stuck in probate for a couple of years. And I said, what's going on? And it wasn't so much probate. She had letters from the court, but her parents died with assets at 13 different places. So the administration was taking her a very long time. Settling an estate, not an easy one, David, but I'd argue, if you have something in place, it'll definitely be a little bit quicker.
Yeah, so a lot of people do expect sort of assets to transfer immediately, and they can when you name beneficiary designations for sure. But when you go through this probate process, then that's where things may take a little bit longer. So since we're talking about that, what is it on average, would you say? How long does it take to go through probate?
So it's almost 16 months. So 15.9 months is the average number of months spent in probate for an estate that's valued between $1 and $5 million. The time and amount really depends on the state you live in. We mentioned before that could be also multiplied if you have property in multiple states. So it's a long, arduous, expensive process sometimes.
Great. So we mentioned earlier that conversations are such an important part of this process as well. How and when should parents share their intentions around wealth distribution? This is a question we get a lot. So Jackie, maybe you can help address this.
Sure. I would say we want to start having these conversations early and often. If you think about the family conversation, yes, money and wealth, they're certainly important, but it goes much deeper in building an emotional connection together. And I certainly understand how transparency can be a difficult topic. There's many variables. So if you think about age, your life stage, your health, your wealth, family dynamics, that might shape the level of transparency that you feel is appropriate now versus what you might choose to disclose at a later date. And then when you think about the family conversations, it can vary and focus on many areas. It could be on financial planning, charitable giving. Maybe it's gifting to family. Maybe it has to do with healthcare planning or legacy planning. But these conversations are going to provide an opportunity for you to express your wishes and fears. And it's also providing an opening to hear from your loved ones and understand their preferences as it relates to the plan that you've set in place. But just because you're allowing your family to voice their opinions and views, it by no means that you're going to give them a vote, right, to change what you've put in place. And I think that's truly important to remember, is that you are remaining in control of the decision-making process. But these conversations can provide not only you, but your family with the clarity and boost the harmony to reduce uncertainty and complexity that can sometimes accompany wealth distributions. And when we think about our intentions and think through them, if somebody is going to be impacted by your decisions, that's where you really shouldn't only focus on your own comfort, but you need to think through the information that your loved ones need in order to navigate their own futures. And if we don't have the family conversations, David, then what's the alternative? When we pass, we can't have an opportunity to communicate our reasoning behind the decisions. We can't address any questions or conflicts that arise among our family.
So true. Such a great point. No one wants their legacy to be one of family discord. So totally agree. Having these conversations early and often are for the better. Now, when we're thinking about estate planning and leaving an inheritance, you touched on this earlier, clients often assume they'll divide their estate equally amongst their heirs, but there are some reasons that might not be the optimal plan for every situation. Jackie, how might families think about this?
Yeah, I think that's a great point. I find that a lot of my clients will often tell me that they want to be fair, but it's important to understand equal doesn't necessarily mean fair, because fairness is always an individual perception. So yes, I certainly work with families and they're planning on leaving their assets equally to children and heirs. And that can work easily and well for things like cash or investment accounts. But let's think about our possessions or our family heirlooms or even real estate. And you can sell these assets, the monetary value can be split, but what if there's an emotional connection? Certain heirs may value the item more than the monetary sum that they will receive. And I think just having these conversations can provide a guide to thinking through how to distribute the assets to not only meet your wishes, but also the preferences of your loved ones. And then you also want to think about the needs of your heirs, as that might vary. And you may decide that the financial circumstances, their career, their lifestyle may warrant a larger or smaller share of the estate. So ultimately, there's just no one-size-fits-all approach. And that's where having these family conversations, coupled with thinking through your objectives, is truly key to ensure that your estate plan is fully meeting not only your needs and intentions, but also what your family's needs are as well.
And I was
Yeah.
thinking too, a lot of times, David, the conversation is around money, right? Jackie, you just talked about possessions and whatnot. You don't have to have these these conversations and say, I have X amount of dollars, right? You can start with where do I want things to go? This is where I've kept things. This is where I've put you in this position, so that we don't have to start with, this is how much money I have. So you can leave the money factor out of it.
Right, right. And I like the point about the personal possessions. And you guys have shared in the past plenty of stories where actually the sticking point in families is like who's getting, whatever, the piece of art or the family china or whatever the case may be. Like often that tends to be more of a sticking point. So once we've done all this, how often should someone revisit their plan? I mean, it's not really set it and forget it, is it, Pamela?
No, well, if you can't find it, it's definitely too old, right? So you want to know where it is. But definitely, I agree. It's not a static document for sure. Your estate plan is not static. So a life event, somebody passes away, divorce, A lot of times, Jackie, you and I see documents that were done when children or beneficiaries were much younger, right? Now they've become adults, so you want to think about that. How about changes in goals? Sometimes family dynamics go a different way and things look a little differently, right? You want to revisit who those fiduciaries are. The government keeps us on our toes. There's sometimes major tax law changes, right? A big one, Jackie, you and I see is I've moved. Well, if you move, you definitely need to dig out those documents and make sure that they're looked at. If you have an unfortunate health issue, maybe your financial circumstances have changed, to they've received an inheritance. I would say Fidelity says at least a minimum of every 3 to 5 years, it's good to dig them out and take a look. And I appreciate that you want to do your estate plan and you want it to just be one and done and never look at it. But unfortunately, again, it needs to be updated when circumstances changed. It can't be one and done because it's something that's kind of evolving as time goes on.
Awesome. Thank you both very much. This has been a super informative session. For me, I think there's some key takeaways and next steps. First, I would start by defining your estate planning goals. Think about your values, the legacy you want to leave, and the needs of your heirs. Second, put the foundation in place. Identify the key decision makers and confirm you have the 4 core documents in place: a will, a power of attorney, a healthcare proxy, and a living will. And then schedule an appointment with your financial professional to review your estate planning goals, your accounts, your beneficiaries, and the legal documents within the context of your overall financial plan. Now, we hope you'll join us for part 2 of our estate planning series next week, where we'll be focusing on how to transfer wealth tax efficiently, including an in-depth discussion on trusts. In the meantime, please reach out to your Fidelity representative to have your specific questions answered. And of course, consult your tax and legal advisors about your own situation. And for more timely market updates and insights on other financial planning topics, subscribe to Insights from Fidelity Wealth Management for exclusive invitations to future wealth management webinars and access to our weekly newsletter. Thanks again for joining us.